everybody. Looks like we have everybody here present and ready to go. So let me ask Ms. Taylor to please call the roll.
Thank you. Chairman Vasquez.
Present.
Vice Chair Schaefer.
Present.
Member Gaines.
Present.
Member Cohen.
Present.
Controller Yee.
Here.
Welcome all. We have everybody here present and we're able to hear everybody. We will go ahead and get this meeting started. There's a quorum present. We will start with the Pledge of Allegiance. If I can get you to stand, we'll start with the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. With that, if I can get Ms. Taylor to please call the first item.
Our first order of business is an announcement regarding the public teleconference participation. Good morning and thank you for joining today's Board of Equalization meeting via teleconference. Throughout the duration of today's meeting, you will primarily be in listen-only mode. As you may know from our public agenda notice and our website, we have requested that individuals who wish to make a public comment fill out the public comment submission form found on our additional information webpage in advance of today's meeting, or alternatively, participate in today's meeting by providing your public comment live. After the presentation of an item has concluded, we will begin by identifying any public comment requests that have been received by our board proceeding staff, with the AT&T operator providing directions for you to identify yourself. After all known public commenters have been called, the operator will also provide public comment instructions to individuals participating via teleconference. Accordingly, if you would intend to make a public comment today, we recommend dialing into the meeting on the teleconference line, as the audio broadcast on our website experiences a 1 to 3 minute delay. When giving a public comment, please limit your remarks to 3 minutes. We ask that everyone who is not intending to make a public comment please mute their line or minimize background noise. If there are technical difficulties when we are in the public comment portion of our meeting, we will do our best to read submitted comments into the record at appropriate times. Thank you for your patience and understanding.
Thank you, Ms. Taylor. And once again, I forgot to remind everybody, I know I stated every meeting, but we're all on the same telephonic line, conference call line. So sometimes it's a little difficult for our staff, especially our transcriptionists, to make sure that they're understanding who's making motions, who's seconding them. So if we would just please be patient with us. And once again, please wait to be recognized so we could announce, so they, as they're transcribing the minutes, they have a clear understanding who's moving a motion or seconding a motion and who's speaking. With that, let me ask Ms. Taylor to please call our first item.
Our first order of business will be item B, property tax hearings. Oral hearing procedures are as follows. The oral hearings will be announced in the order presented on the agenda. When I call the case to be heard, participants, please be ready to unmute and turn on your camera as requested. A Legal Appeals Division staff member will introduce your case, stating the issues for the hearing. Each person on the call will then be asked to introduce themselves and, if necessary, their affiliation with the taxpayer for the record. The board proceedings has received contribution disclosure forms for this morning's hearings from the parties, agents, and participants, except for one agent for GATX, William Gannon. All other forms were properly completed and signed. No disqualifying contributions were disclosed. All parties, agents, and participants are on the alpha listings provided to your office. For this morning's board meeting, there are two property tax cases. The first is B1, Petition for Reassessment of Non-Unitary Value, GATX Corporation, 0503, 1064217. This matter will be introduced by Ms. Garrett, who will provide a brief introduction. Ms. Garrett.
Good morning, Chairman Vasquez and honorable members of the board. In the case before you, the petitioner is GATX Corporation, a rail car leasing company with a tank and rail car maintenance repair facility in Colton, California. Petitioner has appealed its 2020 board-adopted non-unitary value, which was based on the January 1st, 2020 lien date. Today, the parties will present 3 issues for the board's consideration. The first issue is whether the petitioner has shown that SAPD erred in calculating the reproduction cost new and depreciation within respondent's reproduction cost less depreciation value indicator. The second issue is whether petitioner has shown that the respondent failed to account for all obsolescence in petitioner's 2020 board adopted value. And the third issue is whether petitioner has shown that respondent overstated and overassessed petitioner's reported asset costs. The parties have an agreed to resolution on the fourth issue before the board relating to penalty abatement. The parties have asked for the board's adoption of this agreed to issue and will present on the 3 remaining issues for the board's consideration. Petitioner has the burden of proof to show that the 2020 board adopted assessment is incorrect or illegal. The parties are present and ready to present their cases before the board.
I was muted here, I guess. I'm assuming the petitioner is on the line waiting to present. Ms. Taylor?
Yes, they are. They can unmute and turn on their cameras at your direction.
Welcome. Well, let me welcome the petitioner here to the Board of Equalization. You'll have 10 minutes to make your initial presentation, and you'll have an additional 5 minutes on rebuttal. Please unmute and introduce yourself and your affiliation with the taxpayers for the record.
Okay. My name is Bob Federico. I am a tax consultant for Grant Thornton. We are GATX's consultant. I will not be testifying as to value. That will be Joe Calvanico, who should be on the line. I think he said that he was on a phone line. I don't know if that's working or not, but he will be doing the testifying.
Can we check and see if Joe is on the line?
Can you hear me?
Yes, I can hear you. Go ahead.
Okay. All right. All right, Bob, are you completed then?
Yes, I'm finished. We're
Okay.
good.
All right, sir. All right.
Before we begin, Chair.
Yes, Ms. Taylor, go ahead.
We will ask all participants to be sworn before providing their testimony. So we'll be providing a group oath. Please raise your right hand. Do you swear to tell the truth in these proceedings?
Yes, I do.
We do. Yes.
Thank you.
All right. Well, thank you very much, Mr. Chairman and honorable members of the board. Thank you very much for your time this morning, and I will keep it within the time allotted. I prepared a appraisal, and I wanted to give you my just briefly my qualifications. I've been an appraiser. This next year it'll be 40 years. I have a MAI, an ASA, an FRICS, and a CEA designation. I also attended University of Wisconsin, where I received a Bachelor of Arts in Economics. I also attended the John Marshall Law School here in Chicago, where I got an advanced degree in real estate law. I've earned a number of the designations over the years, but as well as I've published many articles with regard to the valuation of machinery and equipment and the valuation of real estate over the years. And so with that background or with that experience and knowledge, I've had the opportunity to work with a number of companies very similar to GATX, and I've valued the assets, the subject assets, for a number based on largely the cost approach. We did supplement with the market data approach, and I'm going to tell you a little bit about our cost approach, and then some statistics I think that will be helpful, as well as the basis of our market data as well. So briefly, what we did is, we used the assessment, the California Assessor's Manual. We used the tables from that particular handbook. And the reason why is that the subject assets, the subject assets are general industrial items. There is nothing specialized equipment. If the descriptions are pretty clear insofar as there's nothing specialized with respect to the machinery equipment that is actually in place. We're talking about cranes, we're talking about containers, we're talking about tanks, waste basins, water tanks, and really that's really about the most specialized equipment the most specialized equipment that's there are really those items, and they all kind of fit within the general industrial category. So we felt that they fit the definition as articulated in the California Assessor's Manual. And just to give you a sense of where we or why we feel that it was applicable is that at the end of the day, our replacement cost new using the information not only in the Assessor's Manual but also Marshall Valuation Service, we found that if you compare the replacement cost new to our fair market value, that the fair market value wound up being 33% of the replacement cost new. That's significant because the average age of the equipment on hand is 16 years. So with saying that it's basically 67% depreciated or 33% good, that implies a 25-year life for the equipment, for all of the equipment. So 25 years seems to be, is the implied life based on the actual market value that we derived, and that is generally a pretty generous life for most machinery equipment. Very few pieces of machinery equipment have a much longer life. In fact, really, for the all intents and purposes, there isn't many that do. What's really significant as well is that by the way, the oldest asset is 53 years old. To just kind of give you an idea of some of the age on the equipment that's actually there, with an average age of 16, as I mentioned. What's also significant is that when we looked at the comparable sales to back up the manual, the tables in the manual, our comparable sales wound up being about 3 to 11% less than the actual lives, or basically less than the value using the tables in the Assessor's Manual. So at the end of the day, we felt it was pretty applicable, and not just to really kind of punctuate it. Then is that when we compared the market value of the tanks on site, that using the direct cost approach, using the size of each of the tanks, the capacity and size of the tanks, the actual replacement cost new and resulting value based on Marshall Valuation Service, we wound up being that was actually 70% less than the tables. So we used the tables, and we felt that we were being generous overall with respect to the overall value, and that it seemed to corroborate what the actual Assessor's Manual articulated. We also used an amount for economic obsolescence. And the reason why we used economic obsolescence, I'm not sure if you have my appraisal in front of you, but there's a section in there called the industry, basically the industry overview and the company's overview. And at the conclusion of that on page, I'm going to tell you that here in a second. Bear with me a second. On page 8 of the industry outlook, one of the things that was significant, and this is why we used the economic obsolescence penalty, was when the industry overview and outlook was written, it was positive, largely because at that point in time there was a speculation that the U.S. shale oil and gas production business was going to expand in the United States, and we all know that has not happened, and it started to decline as early as 2019 or late 2019, which pretty well buffets or brackets the date of valuation, late 2019 into early 2020. So they had felt that it was going to increase at that point in time around 2.5%. And really, in essence, what it did is it dropped actually very similar to the obsolescence percentage that we articulated. That was based on a scale factor, which is a measure used by appraisers that is pretty typical and well thought of in the industry. And our obsolescence was pretty well underscored by not only that scale factor, but seemed to compare up pretty well to the industry factors overall. So just to reiterate, our fair market value of $8,254,000, then 59.79% of that to reflect the 4R Act is $4,662,000. And just to point out is that the economic obsolescence, if you were to take that out, my value is still $5,560,000, which is a fair amount less than the value of almost $5 million by the state. And here again, I felt that the factors that we used were well underscored by the overall market and the published cost data that was available to me. And that's it. If you have any questions for me, I'd be happy to entertain them.
Thank you. Let me move on then to our State Assessed Property Division for their presentation, which is Mr. Moon, and then we'll allow you to respond to that after his presentation. Is Mr. Moon available
I am.
to give his presentation?
Yes, I'm here. Good morning. Richard Moon with the Legal Department, and with me are Mike Harris and Vincent Giese, Jack McCool, and Robert Wynn, all of the State Assessed Properties Division. In this case for GATX, what SAPD had done for their appraisal is used the reproduction cost less depreciation approach for their equipment and comparable sales for their land. Then they applied appropriately the 4R Act percentage and arrived at the 2020 board adopted value of about $8.1 million. And this is fully consistent with the board adopted value last year and the fact that they added roughly 1.6 million in property this year. I would also mention at the outset, I think I heard a petitioner state that they had also used a comparable sales method in their appraisal, but I think that's the first time I'm hearing it. I may have missed it, but I will point you to his own appraisal, which on page 11 says, we did not employ a market data approach to the valuation of the subject. There's little data that could be utilized to identify the tangible asset portion of each market transaction. And so if he does have, in fact, have data, that's something, of course, that we could look at, but not at this point. Certainly for next year, if they'd like to pursue it, I'm sure SAPD would be more than happy to look at that. The initial petition originally requested a $3.4 million reduction, but they changed that request to $4.662 million without really explaining the cause. But this would represent about a $2.8 million decrease from last year, even though they added about 1.6 million in property this year. GATX, as you know, did provide an appraisal report that's the basis for their reduction request. However, there were a number of issues with the report such that we cannot recommend any reduction in value based on it. And so I'll go through some of the issues that we had with that report, and they should cover the issues that were mentioned by the appeals attorney at the outset of this hearing. For that appraisal, the first issue that we had was that the appraisal used index factors, as petitioners had stated, that are contained in our Assessor's Handbook 581, and that are also reflected in a CAA, a California Assessors Association issue paper that publishes business assessment factors every single year. The only problem is these are the wrong factors to use for state assessed properties. And SAPD calculates its own factors that are more specific for state assessed properties. The index factor tables used by GATX are for commercial, industrial, and agricultural and construction equipment, which does not fit into the factors that SAPD had developed. We should also point out that the GATX California location does not match the industry company type categories that are listed in the assessor's handbook. But in any case, those factors, as the assessor's handbook says itself, are for locally assessed, county assessed properties and not for state assessed properties. The second issue that we had was that the appraisal applied a 125% maximum trend factor that's recommended guidance, again, for locally assessed properties. And further, this factor is used in conjunction with a minimum percent good factor, but the appraisal used the maximum factor, but not the minimum percent good factor with no explanation. The SAPD factors, on the other hand, that should have been used and that apply to this property do not apply a maximum trend factor, and they do not cap a minimum percent good factor. The third issue that we had was with the obsolescence adjustment. They used an inutility adjustment, and that's for a reduced utilization of the property, but the calculation was largely unsubstantiated, and specifically, no detail was really provided for two major components of the formula, which are capacity and scale. So for capacity, petitioner used a table produced by the Federal Reserve, even though that table is not appropriate for use to determine petitioner's specific capacity. And for the scale factor, the precise scale factor used was not even stated in the report. SAPD had to reverse engineer what scale factor was used and then ask petitioner to confirm that at the appeals conference. Thus, petitioner is requesting about an 18% reduction to its property for inutility without explaining why the numbers used to calculate that reduction are appropriate for this property. And particularly for property, some of this property that's already valued at salvage value. The board has published guidance as to how to properly demonstrate utility, and petitioner has not followed that guidance. And then finally, SAPD discovered that about half of the listed property had lower useful lives than what SAPD uses. And of course, lower lives are going to reduce the value of the property, but petitioner has not explained why the lives and why the factors that are used are incorrect, or why the ones that they have used are correct. And for these reasons, we recommend no value reduction for the substantive appraisal reasons or issues that are raised here. However, SAPD did apply a penalty for late filing, but due to a processing error, reported it incorrectly, depriving petitioner an opportunity to request abatement of that penalty. And for that reason, SAPD is recommending removal of that penalty amount and no other change to the board adopted value. Thank you very much, and we'd be happy to take any questions.
I've got a question if I could, Chair.
Thank you, Mr. Moon. Members, I have several questions myself. I was wondering if we could just hold our questions until after we allow the petitioner to his 5 minutes for rebuttal. If we can hold that. Okay.
All right.
Is it Mr. Federico or is it Joe? Who's going to do the rebuttal?
This is Joe Calvanico. I'll follow up on that.
Okay, you have 5 minutes.
Thank you, sir. Thank you, Mr. Chairman. I appreciate it, and honorable members of the board. And the one thing I agree with one thing that the state said, and that I did not follow their guidance. I'm a professional appraiser appraising one particular group of assets, and using mass appraisal advice doesn't necessarily always lead to the most accurate value. As the state pointed out, that they say that this is state assessed property, which is true, but it's a non-unitary asset. So the non-unitary assets are assets that are not included in the entire approach, and can be are classified that way because they don't necessarily fit the entire business model. In this particular case, as I mentioned, most of this was fairly standard industrial equipment that is found on site. And in fact, the state assessed manuals reflect that definition in terms of in terms of the assets that are overall covered by all the tables within the context of the quote unquote locally assessed property, including manufacturing machinery equipment. And as I pointed out at the outset of my presentation, that that our value implies a 25-year life, and as I mentioned, that's probably higher than most of the lives, even within the state assessed area. So overall, we think it reflects value. And the other thing that that I want to mention from that perspective is that within the context of the market data, it's absolutely true in the report that we said that there was no market data for an entire facility such as the subject, and that's what that was necessarily articulating. Essentially, it would be imprudent as an appraiser just to trust tables overall. So I, of course, have market data that I use to substantiate what I have, and I'm articulating that now because obviously it's called into question, and the fact that the assets that we used from the market data definitely underscore and agree with the factors that we used that were from the state overall manual. With regard to the second item that they mentioned with regard to the 125% rule, you know, there's general guidance in there and for locally assessed properties. It's absolutely true. But the interesting thing is that there's actually no rule or statement that's stating that it's not recommended for state assessed non-unitary property. So it would be inaccurate to say that you shouldn't use it. And in fact, these assets, because many of them are older, this absolutely applies to each and every one of those assets as a result of that. And as I pointed out, our overall market value with obsolescence, using that scale factor, which was really based on the reduction in the industry or the decline in the industry, is well articulated. And as I mentioned before, even if you take that out, if you take that inutility factor out, our value would be $5.56 million, which would still be less than the $7.6 million that the state has. So that's that.
Thank you. I think it was Member Gaines had a question, right? We'll open it up to the members.
Thank you very much, Chair Vasquez. I just was curious because Mr. Moon had mentioned that the penalty was waived. So I was just curious as to how much that penalty was.
Yeah, so the penalty is not waived. What we're asking the board or recommending that the board do is abate that penalty. We as staff, of course, can't remove that. Okay. And so that would be, yeah, and so that would be up to you to approve that. The amount of the penalty, I'll get that in a second, is $683,000 roughly.
Okay. Okay. Very well. Thank you. Appreciate that. And then I'm just curious as to this argument in reference to a 25-year depreciation table, and I believe it was Joe Calvinico that had expressed that he thought that was the proper time frame of depreciation, and I was just wondering if Mr. Moon, could you respond to that in terms of his logic and thought process?
Yeah, well, I certainly don't want to speak for his logic and his thought process. In terms of the 25-year lives, what I will say, I'm actually not exactly sure what he's saying, but you know, again, okay, the lives and the factors that are required to be used are the ones that the SAPD produces, and perhaps one of our appraisers, Vincent Giese or Mike Harris, would like to chime in.
Sure. Okay.
Are they on the line?
Yes.
Yes. Hi. This is Vincent Giese. Good morning.
Good morning.
Yes. I believe that 25 years may be an average that he came up with. I don't know how he came up with it. We used a lot of different lives for different categories of property. I will mention that the facility is 72 years old and it was built in 1948. So many of the assets are older than 25 years.
Mm-hmm. Okay. And could you speak to the Marshall valuation technique?
Well,
are they just using a different model for valuation of property than the state uses?
Well, he didn't use the Marshall valuation for index factors or percent good in his appraisal.
Okay. So maybe he could, maybe if I could get that clarification then from Mr. Calvinico in terms of, can you clarify how the Marshall valuation was used in this?
Yes, sir. I can. So Marshall Valuation Service, and I don't know how familiar you are with it, and if you want me to just explain it a little bit more, but it's published cost data that most appraisers rely on. When we
use it in the insurance business, so that's the reason I'm familiar, a little bit familiar with it. But
very well, sir. Then you're very familiar with it. So the reality is, as you know, is that the published cost data is pretty accurate. And one of the things that we did was in using the factors that we used, the factors in the lifing, we corroborated that with Marshall data, with the Marshall valuation data, and it was consistent with that for this specific equipment, including what I mentioned earlier, the tanks and some of the specific assets for which we found market comparables for. And so they reflected the lifing that we used overall. And as was said, is that so the 25-year life is certainly the average for, well, not even an average. What it does is the value, the fair market value that we derived using the lifing. If you were to compare it to the replacement cost new, then that would imply a 25-year life. And so obviously within the context of, even though it's as I mentioned, that there's a 53, the 53 is the oldest asset that's on site still. The average age is about 16. So that would definitely, and that was reflected in the Marshall Valuation Service as well.
Okay, and then I'm wondering, thank you. Mr. Moon, can you help me a little bit on this valuation in terms of the depreciate? How is the state depreciating it versus this proposal coming forward in this Marshall valuation?
Yeah, I don't know what the difference between our depreciation factors that we use and the Marshall factors are. I think Vincent Gazy would be a better person to answer that question.
Yeah, great, thank you.
Yes, Mr. Gaze, Vince Gazy here. I believe our appraisal, State Assessed Properties Division appraisal, we used different life tables than the petitioner. And it was based on our what we use for railroad maintenance facilities in the state of California, and also based on the age of the equipment and age of the facility.
Okay, all right. So it's not there's not a specific table out there you're looking at?
No, we used different life average service lives for different property that they owned. Also, okay. I might mention that they do own quite a bit of buildings and paving out there, not just equipment. So.
Okay, and so the tables that the state is using are specific to that particular type of property?
Yes, we used 12 different index factors for different categories that we saw that they owned and used and possessed. For example, I'll give you an example. We used index for buildings and steel, buildings and wood, building and improvement, paving, asphalt, paving, concrete, tanks, water wells, and railroad freight cars. So we're very specific in our trend factors that we used for their property.
And I'm just curious as to how Marshall does it. Are they as specific?
Well, I don't think they used the Marshall and Swift for their index factors.
Okay.
They used the Assessor Handbook 581, which is for county assessed properties,
Okay.
and they used a very generic for commercial and industrial, agricultural, and construction property.
Vince, this is Mike Harris. Can I step in here?
Yes, please do.
I want to clear up something. We also incorporate a Marshall in our development of our index factors. However, we narrow our focus on the specific type of equipment that you would find in this facility in railroad property. So while we both, I think, from what I understand of the petitioner's use of the county factors, they're a little more broad in how they apply it, because they're covering more property, more different pieces of equipment are incorporated in their factors, where in ours use of Marshall Swift, or Marshall valuation, we're more focused on the railroad property.
Okay, now you're speaking to the petitioner, or are you speaking to Marshall valuation?
Well, I'm talking about how Marshall valuation is used.
Yes, okay. Okay, so the petitioner is using it in a more extensive basis than we would.
Right, well, the petitioner has taken county factors that are much broader in use, covering different, much broader categories of equipment, where at the State Assessed Properties Division is using a more focused, narrow category for just railroad type property and specific property that's found at this facility.
Okay, that's helpful, thank you. And then just in closing, if I could have Joseph Calvinico, if you could just respond to that. And
Certainly.
Done, thank you.
Yeah, and just to give you an idea, so I heard that there were a number of different categories that the state used, and just to let you know, we used about 30 different categories, and we were very specific about the particular items of equipment because, as I mentioned, we're using the valuation of one particular taxpayer and one facility, and so when we went to corroborate the actual factors and the lifing used, is that it was specific to the actual equipment and use within the context of the subject property. And so that when we went to the California Assessor's Manual to use the particular lifing for the particular broader category, we went to Marshall to see within the context of the 30 categories we had, how they translated to that. So the 30 categories that we did have actually, in terms of, and I'm happy to articulate each and every one of them to you if you'd like.
So 30, yeah. How about just, 30 categories versus how many used by the state?
Vince, do you have that?
Well, I believe he might be referring to the percent for the life to use for percent good, but that's not the case for trend factors. And also the information he just presented, it's not in his appraisal.
Okay. So that's not clarified in the appraisal?
No, it's not.
Okay. All right. Thank you very much. I appreciate it. It's clear as mud.
Yes, thank you.
Chair Vasquez, Vice Chair Schaefer here.
Yes, Vice Chair Schaefer, go ahead.
I have a question to the petitioner. The respondent alleges that you used the wrong factors, agricultural factors or county property assessment factors in calculating the value of the state assessed property. I'm not sure what you're talking about there. Is that true? And please explain.
It's actually not true. And there are several tables that we used overall, just in general, and in the appraisal. And each of those categories that I talked about are articulated in appraisal. In fact, If you look at pages of the appraisal, which include each of the equipment tables that we did use, sir, if you start on page 13 and go through bear with me a second, I apologize. 34, so 13 to 34, each and every specialized listing, or the asset listing is there, along with the actual tables and the commercial percent good. And they for each of the different factors that we used not factors rather, but the depreciation schedules, we used it for the appropriate equipment overall, including industrial, commercial. We applied them directly to the correct items, including agricultural is a misnomer because it's also construction equipment that's looped into there, and there are things that are construction equipment on site, and so we included those as well.
All right, thank you. I also would like to ask our staff, we all agree on abatement of a penalty here?
I'm sorry, Mr. Schaefer, are you asking that of staff, or are you asking that of your fellow board members?
I'm asking that of staff.
Yes, staff is recommending that the board abate that penalty.
All right, I'd like to ask, are we pretty quick to assess a penalty? I would be happier if we didn't have to abate it because we never tagged it into the valuation. I think we are admitting some negligence on our part in giving the penalty in the first place, and that's why we are abating it. It costs the public and it costs the petitioners a lot of time and money to go in and ask for abatement of it when they have pretty good reason for it. And when they have pretty good reason for it, it just raises my mind. I guess maybe I'm pro-business here, is that we should have been a little slower to assess a penalty that we can't defend.
Mr. Schaefer, if I could respond, we're statutorily required to assess this penalty if the filing is late. And so what we do, the mechanism that the board has, is that because we're statutorily required, we put the penalty on if they're late. And then if there are circumstances that make it reasonable that it was late, then staff will recommend abatement to the board. And in this case, we believe that it is reasonable that the penalty be abated because of the processing error that staff had made.
All right, thank you. I would like to be considered as favorable and on us abating penalties or not assessing penalties. I think we have to realize that any business interest from the little guys to the big guys is having a much tougher time this year than they've had before, and we should help them out whenever we can legally do so. Thank you.
Mr. Chairman. Mr. Chairman.
Yeah, I think I hear, Controller Yee, I can't see you, but I think I hear you.
Okay, I'm on. Good.
Go ahead.
Good morning.
Go ahead.
Good morning, members. I just wanted to make an observation about this appeals case. It is one that I have some concern about with respect to what the petitioners are relying on with respect to the guidance on valuation. And I appreciate Board Member Gaines's questions about just what all was incorporated into some of the calculations. But a really threshold issue here, and I want to be sure that petitioners understand this, and that is what application of guidance is actually being conducted here. And it looks like a lot of the guidance petitioners relied on are standards that have been established for county assessed properties. And even though they are standards and guidance for county assessed properties, it's not to say that even counties are going to be mandated to look at applying those at every turn. There are going to be unique situations that where they're going to have to apply that appropriately. But I'm just concerned that year after year, when we do the valuation for this particular petitioner, that we understand that the guidance that should be relied upon is, first of all, Property Tax Rule 6, which this board adopts, that relies on essentially the reproduction or replacement cost approach to value. That is the preference when neither reliable sales data or reliable income data are available. And then just taking it from that particular threshold guidance to then apply more specific factors that are adopted by this board for state assessed properties. And so I'm just a little concerned that I don't want petitioner to be repeating, I guess, this reliance on county assessed properties guidance documents that are include the assessor's handbook as well as the California Assessors Association guidance as well. And so I just wanted to point that out because to Mr. Schaefer's point, I mean, I think our time is all valuable, but I want to be sure at the very least at the threshold level that we're applying the appropriate guidance for the properties that are rightfully before this board. So I just wanted to make that observation and believe that the state assessed properties has appropriately determined the valuation for this petitioner.
So I'm Joe Calvanico. Am I allowed to respond to that?
Sure, go ahead.
Okay. The way I understand it, and correct me if I'm wrong, but the mandate in the state of California for assessed property is market value. What I provided to you as an appraiser is my opinion of fair market value of this equipment. It doesn't really matter how, well, it does matter how I came up with it, and I explained how I did. The reason why I gave it to you in the terms that I did was largely because of the fact that the California Assessor's Manual has particular tables, and whether or not they're mandated, if they reflect market value and they are consistent with things like Marshall Valuation Service, which is a service that most appraisers rely on to help provide market value, in addition to comparable sales and the like. That's what comes up with market value. So it's not a matter of using incorrect guidance or anything like that. What it is it's coming up with market value, and that's what I did.
Well, we're
may
trying
I respond briefly?
Yeah, thank you, Mr. Moon.
Yeah, I would just say it's of course absolutely right that what we're mandated to assess is market value, but we have standards and guidance that help us to get there. And it sounds like, and quite honestly, I'm a little bit confused, but it almost sounds like what the petitioner is saying is that they came up with a study or they did a study of their own trend factors and index factors. And if that's the case, and if that fits better than our factors, then we're more than happy to look at it. But I don't believe that was in the appraisal. What was in the appraisal was just that they used the AH581 factors. And based on that, we would not recommend any kind of reduction. Thank you.
Thank you for that clarification. Controller Yee, did you have more questions or is that?
No, I was just, thank you, Mr. Moon, for that clarification. I mean, this is not by any means a strict formulaic method of how we get to evaluation, but we're certainly happy to look at methods that were employed that are consistent with just how we look at state assessed properties generally. But what I am saying is that I hope the petitioner understands that this board actually does adopt factors that are more specific, and I just really am perplexed as to why kind of the more generalized factor tables were employed here on the part of the petitioners that are more appropriately for county assessed properties. Thank you.
Thank you.
Could I do a follow-up question at the?
Sure, we have two. I guess we'll go with Member Gaines and we'll go to our Vice Chair Schaefer. Go ahead, Member Gaines.
I just wanted to follow up with Mr. Moon in terms of the factors that we are using. Are they, I mean, the argument by Joe Calvanico is that they don't reflect the market. So, then the question is, do we need to adjust our factors? And I don't know the process for doing that, but I just thought I'd ask the question.
Yeah, I mean, if that's his argument, and again, I'm a little bit confused as to if that's the argument at all, but if that's the argument, then I think what it would behoove him to do is to give us his reasons prior to this hearing, along with his actual appraisal. If he has reasons why he thinks his factors are more appropriate than our SAPD adopted factors, then we're more than happy to listen to his reasonings and to make a determination as to whether that's the case. And then we would also look to see if that applied only to this specific property or to all kinds of this general type of property as well, to see if an overall adjustment would need to be made to our factors.
Okay, so what is the process for that? You said it should have been done earlier. So what is that?
Typically, it would be done around the March, April, May timeframe. The property statement is due March 1st. I think that's also true for railroad property, although I could be mistaken on the date. But typically, about that time frame, an assessee would present whatever information that they have to support a different value than what the SAPD had come up with.
Okay,
and then there would be back and forth from that.
Okay, all right. And is the petitioner, were they aware of that? That they could have done this in March?
I'm not sure if they were aware of that.
Or should they be aware of it? I'm just trying to.
They should be aware of that.
What's going on? Maybe I could get a response from Joe Calvinico.
So I'm the appraiser. I think I turned that over to Bob, who was the consultant, the consultant, and the company hired me.
Yeah, I'd like to hear from Bob.
Yeah. If I understand you, I think what you're saying, Mr. Moon, is that type of information maybe would be more useful sometime after the return is filed. Is that what you're getting at in terms of?
Well, I think what I'm saying is that type of information would be more useful when our appraisers have time to look at it and give it the the attention that it deserves.
Understood.
Wonderful. Great. Thank you.
Vice Chair Schaefer, I believe you had a question.
I wanted to ask Bob Federico, if we applied the factors that you used in your petition, how much of a difference would this make in the valuation? In other words, is there a dollar figure of how much lower your valuation would be?
I would have to defer to our appraiser, Mr. Calvanico.
Sure. So without the inutility factor, sir, what we would wind up with is a value of $5.56 million versus a value of $7.46 million.
But you're more or less happy with our stipulation here. Well, that's all been figured into the stipulation you have with Mr. Moon. Hello?
Yep.
Okay.
That would be for Bob to address.
Yeah, I'm not sure of the question, Mr. Schaefer. Can you repeat that?
Oh, well, he gave me a figure that was, I think, granting you more relief than you're agreeing to here. But all figures considered.
Then we were asking, yes. Yes.
Okay, well, I'm content with that. Thank you.
Any other questions from any other members?
Yes, I have a question.
I don't see you on the screen here, but I'm assuming you're there somewhere.
That's true. I'm not on the screen, but can you hear me?
Yeah, I can hear you. Go ahead.
Okay, good. So Controller Yee kind of started down this road. I just wanted to ask, is there any direct evidence of retired assets? Mr. Federico?
Joe, I think you can answer that one too. I know that was part of one of the issues.
I think there were a grouping of assets that both the state and I valued at zero.
And if that's, I'm not sure if that's a reporting issue where assets that were retired were not reported or removed from their books. I'm not sure. We'd have to get with our client on that one.
Member Cohen, are you still there? Are you muted? Maybe you're muted. If you're speaking, Member Cohen, I can't hear you. I'm not hearing Member Cohen, so is there any other?
Mr. Vasquez, I'm sorry, this is Dan Jenkinson with the board. I'm just observing, but I was just kicked off. So she might have been kicked off as well. I had to sign back in, just so you know.
Thank you.
Yep.
Well, let me ask a quick question. Actually, most of my questions were answered. The only thing I have is just, I guess, more of a clarification from the petitioner. And it sounded like you kind of addressed it, but I just want to be clear on this. So are you saying that your calculations specifically requested by, the factor of your tables are more accurate than the calculations by our staff?
That is correct, yes.
Okay. And then the other, and then I guess we touched on it a little bit when we were getting into the explanation about the 125%, I guess, across the board. Can you explain that relationship between the technology advances and the appraised value of your assets?
Yes. So, I mean, basically the rule, it's basically the idea behind that particular application, or it's not a rule, but let's call it an application, is that as an asset gets older, that basically that as you trend it forward to present day, that going beyond 125% of the original cost would not necessarily be reflective of the actual market. That's really what it means, and we agreed with that.
Thank you. Okay.
Mm-hmm.
With that, I'm looking at my notes. I think I'm pretty good here. Let me just check. Is Member Cohen back on the line? I'm not seeing or hearing her. While we're waiting for that, let me ask Ms. Taylor, do we have any public comment on this item?
We do. We don't have any written comments, but I can ask AT&T moderator to let us know if there's anyone on the line who'd like to make a public comment regarding this matter.
Please.
AT&T moderator, can you please let us know if there's anyone on the line who would like to make a public comment?
Okay, ladies and gentlemen, if you would like to make a public comment, please press 1, then 0 at this time. Once again, if you'd like to make a public comment, please press 1, then 0. And allowing a few moments here for anyone to queue up. So far, we have no one in queue.
Thank you. Do we have Member Cohen back on? I think she may have fell off our line here because I don't see her and hear her.
Yes, I'm here. I'm back.
Oh, I'm sorry.
Thank you.
I was just checking in. I think I wasn't sure if you were finished with your questions.
Mike, I'm finished. Thank you.
Okay.
Thank you.
With that, members, this item is now before us.
Mr. Chairman, I'd like to make a motion.
Sure, go ahead, Controller Yee.
I'll move that we grant the petition for reassessment in part, consistent with the recommendation as to the agreed to penalty abatement issue, and to deny the petition as to all other issues.
Vice Chair, I would second that.
It's been moved and it's been seconded by our Vice Chair Schaefer. Any comments or questions from any of the members?
If I could.
Yes, Member Gaines, go ahead.
Malia, did you want to speak first?
Actually, thank you very much. Mr. Chair, just wanted to say that in abundance of caution and to avoid any appearance of conflict, I'm going to recuse myself from this vote.
Okay.
Thank you. Thank you, Mr. Gaines.
Thank you.
Thank you, Member Cohen. Great. It just seems to me that this process, while I'm sympathetic to businesses and how difficult it is to do business in the state of California, that we have a process through the BOE, and I would think the petitioner would have an opportunity even next year to ask these questions and do it in a little different time frame. Ask those questions up front in terms of whether it's accurate to what's occurring within the marketplace. Do that in the March time frame, and if we adjust accordingly, then we would have a more accurate valuation method at the BOE. If there was still disagreement, then that could come forward, but we as members would know that that was challenged earlier on in the process. And I just think that, I want to make sure that our standards are accurate, but I think that process didn't occur in this case. So I cannot support it. Thank you. I would agree. Actually, I would agree with Member Yee's motion. Thank you.
Controller Yee? Yes,
Yeah.
go ahead.
Thank you. I appreciate Board Member Gaines's comment, particularly directed to the petitioners. I will say that this is a process where there can be quite a bit of give and take if petitioners come forward with documentation of their analyses and certainly how they've arrived at certain factors to be considered. And so, but the burden of proof is on the petitioner. And maybe this is a good reminder to all petitioners during the state assessed valuation process that, after the property statements are due, there is just this ongoing I think from the State Assessed Properties Division staff of wanting to engage to get to the right valuation. I mean, this is, we're really trying to do that. And I know the staff there really do try to help petitioners do that. They will welcome any analyses, studies, appraisals to help get to that point. And, our goal here is just to get to the right valuation given the guidance that we rely on. But I will say too that and this is not directed to the petitioner, but oftentimes I think without understanding the guidance and standards that are available to be applied here, that the tendency is for those who come before the board to get to the, frankly, the best valuation they can using all different methods, without regard to whether they are applicable for county assessed properties as compared to state assessed properties. So I think we have a mismatch here, and that's to me a threshold issue, which is why I made the motion that I did. But I think your comment is well taken, Member Gaines, and that is start that engagement much earlier in the process.
Thank you. Any other comments or questions? Seeing and hearing none, let me ask Ms. Taylor to call the roll on the motion.
Thank you, Chairman. Chairman Vasquez?
Aye.
Pardon me.
Vice Chair Schaefer?
Aye.
Member Gaines?
Aye.
Member Cohen is not participating.
Actually, Ms. Taylor, I misspoke, I got ahead of myself. I will be voting, and I'm voting in support of the motion on the table. Thank you. Aye.
Thank you. Controller Yee?
Aye.
So that's unanimous of all of those present and voting. Thank you. With that, let me have Ms. Taylor please call the next item.
Thank you. Chairman, may we take a brief recess to bring our next oral hearing participants into the meeting? Perhaps maybe 3 minutes or so? Oh, you're muted, please.
I'm sorry. Is 3 minutes enough?
Perhaps 5, so we can just do a mic check.
Let's do 5 to be safe.
Thank you.
So we'll be back at 11. I have, according to my clock here, 11:18 then.
Thank you.
Thank you. Taylor, if you would please call our next item then.
Let me confirm that we're live.
Okay.
And the public
AT&T
is-
moderator, please confirm that we are live.
Go ahead, you are live on the call. All lines are connected.
Okay, it sounds like we're live. Ms. Taylor, please call the next item.
Thank you. The next item on the agenda is B2, petition for reassessment of unitary value. There is one oral hearing, Southern California Edison Company, 0148. The oral hearing procedures are as follows. Please be ready to unmute and turn on your camera as requested. A Legal Appeals Division staff member will introduce your case, stating the issues for the hearing. Each person on the call will then be asked to introduce themselves and their affiliation with the taxpayer for the record. Contribution disclosure forms were required and were received from the petitioner and the representatives prior to the beginning of the board meeting. This is a constitutional function. All other forms were properly completed and signed. No disqualifying contributions were disclosed. All parties, agents, and participants are on the alpha listings provided to your office. This matter will be introduced by Ms. Garrett, who will provide a brief introduction.
Good
Mr.
morning
Chair.
again.
Good
Chairman
morning.
Vasquez. and
Go
members
ahead.
of the board.
Pardon me, ladies and gentlemen, I'm sorry.
Oh, yes,
Board
yes.
Member Cohen, I had my hand raised a couple times and it was lowered, but I just wanted to state for the record that I'm going to be, in an abundance of caution, going to be recusing myself from this item. I'm going to turn off my camera and unmute myself for the duration of the discussion, and my staff will signal to me when I can come back on. Thank you.
Go ahead, Ms. Garrett.
Thank you. In the case before you today, petitioner is Southern California Edison Company, a public utility operating in Southern, Coastal, and Central California. Petitioner has raised 6 primary issues with its 2020 board-adopted unitary value, which was based on the January 1st, 2020 lien date. Respondent has reviewed the contentions raised by the petitioner and has recommended an adjustment as to Issue 5, which is related to the treatment of self-insured retention expenses, and Issue 6, related to obsolescence. Additionally, petitioner has indicated agreement to respondent's recommendation on Issue 5 and Issue 6 for purposes of this hearing. Accordingly, based on this agreement, the parties are requesting the board's adoption of their agreement as to Issues 5 and 6, and thus will not be substantively presenting on these 2 issues today. Today, the parties will present on the following 4 remaining issues. First, whether petitioner has shown that respondent erred in placing 75% reliance on the historical cost less depreciation value indicator and 25% reliance on the capitalized earning ability indicator of value. Second, whether petitioner has shown that respondent must adjust the board adopted value for petitioner's $4.5 billion accrual for liabilities for the 2017 and 2018 wildfires and mudslides. Third, whether petitioner has shown that respondent improperly assessed $400 million of wildfire mitigation capital expenditures. And fourth, whether petitioner has shown that respondent erred in its treatment of wildfire insurance fund related contributions. Petitioner has the burden of proof to show that the 2020 board adopted assessment is incorrect or illegal. The parties are present and ready to present their cases before the board.
Excuse me, Chairman. This is Ms. Taylor.
Yes, go ahead, Ms. Taylor.
Ms. Taylor, Mr. Chairman Vasquez, we've received a request to take a 1-hour lunch break from noon to 1 p.m. today.
Yes.
Okay. I just wanted that to be known to our participants. Thank you.
Yes, I was aware of that. So depending on where we're at, we'll break. I mean, right now we're about 40 minutes out.
Great.
So if for some reason we're in the middle of this, we'll take a break. And with that, I'm assuming the folks from Edison are on the line, and welcome to the Board of Equalization. You have 30 minutes to make your initial presentation, and then you'll have an additional 10 minutes on rebuttal. Please unmute and introduce yourselves.
Good morning.
Good morning.
Good morning, Mr. Chairman and members of the board. My name is Marty DeKessian, and my firm, DeKessian Law, represents Southern California Edison. With me today are Ms. Andrea Wood, who is the Vice President of Tax with Edison International, Carl Matthews, Principal Manager with Southern California Edison, and David Lee, Tax Manager with Edison International. Also with me today are Jason Chow, Greg Manos, Cornelia Lyons, and Kevin Alvarado of the international accounting firm of Ernst & Young. EY studied staff's valuation and issued its written findings, which you have in your materials as Exhibit D. So before we get started today, I would like to play for you an audio clip that I think will help set the stage for our discussion.
Mr. DeKessian?
Yes, ma'am.
This is Mrs. Taylor. We do need to swear in all the participants that you listed. So if everyone would please raise their right hand and answer, do you swear to tell the truth in these proceedings?
Yes. Yes, from Jason Chow, EY.
Thank you.
Yes, Carl Matthews.
Yes.
Greg.
Yes, David.
Yes, Greg Manos from EY.
Yes, Kevin Alvarado from EY.
Yes, Cornelia Lyons from EY.
Thank you. Mr. DeKessian?
Thank you, Ms. Taylor.
Essentially, you're being chased by the fire. I've never seen anything like that. My brain remembers it as a nighttime event, but that's because I never saw the sun, and it was the middle of the day. And the way that fires are happening now with warming climates, we can't stop them in landscapes like this. When you're seeing just the magnitude and the power.
The sound went out just a second. For some reason, my thing muted. Give me just one moment.
Sure, go ahead.
My brain remembers it as a nighttime event, but that's because I never saw the sun, and it was the middle of the day. And the way that fires are happening now with warming climates, we can't stop them in landscapes like this. When you're seeing just the magnitude and the power and the speed of the fire, seeing a tree blow up in front of you. We need to do 5 to 10 times more per year to really get a handle on this. It's happening now. The worst case scenario is just starting to set on. We are witnessing the beginnings of extinction of forest in a lot of California. It's not hyperbole, it's simply happening. We have more fire, more destructive fire. All that is the new normal.
Thank you for indulging us, members of the board. The clip that I just played for you quite obviously relates to California's unprecedented wildfire crisis. It seems that every year we're breaking some sort of wildfire record, whether it was the Tubbs Fire, which in 2017 set a record as the deadliest fire in California history, and the Camp Fire just 1 year later in 2018 broke the record of the Tubbs Fire, or the August Complex Fire, which just a few months ago became the largest fire by acreage in California history. It's pretty clear that the wildfire crisis is no longer something that happens once every few years, nor can we even consider it a season. It is year-round in scope, and it is constant. As former Governor Jerry Brown indicated in that audio clip, it is our new normal. If I can direct the board to slide 3 of your slide deck. Here we have a table that indicates the dramatic increase in acres burned due to California wildfires over the past several years. If you look at slide 4, you can see the largest wildfires in California history by acreage have occurred, the top 7 have occurred in the last 3 years.
Excuse me.
Yes, sir.
Member Gaines, I don't see a chart. I don't see any image.
Slide 3 in your slide deck. You should have a slide deck, Member Gaines.
Okay, thank you.
I apologize if you don't have it, but It's a chart that has orange squares on it, black background. And what it does show is a sweeping parabola, half a parabola, kind of if you follow the trajectory of the line of the increase in wildfires in recent years. And the same with slide number 4, and the same with slide number 5, which is also a table that shows the most destructive fires in California history by any metric. This happens to be by structures and deaths, but 10 of the top 14 in the past 3 years. So members of the board, the evidence is beyond dispute that we have a wildfire crisis unlike anything anyone has ever seen anywhere at any time. And it confirms what we've all been observing in our daily lives. In fact, I'm not sure there isn't a single one of us that hasn't been impacted by the wildfire crisis in some way. And for us, just as obvious as the wildfire crisis itself is the impact of the crisis on the viability of our electric utilities. The wildfire crisis, this is a matter of public record, has pushed PG&E into bankruptcy in what Columbia University professor John McWilliams called the first climate change bankruptcy in history in his testimony before the United States Congress this past January. The new normal has created medicine, as we're going to discuss. Scholars and scientists have warned that this is going to get much worse. And experts are saying that the ongoing viability of our electric utilities has been called into question. Slide 6, for example, captures just one headline. If you do any sort of even basic Google search for this, you'll see it all over the internet. Our discussion today concerns an important related subject, namely the impact of the wildfire crisis on the value of our electric utilities for property tax purposes. This impact, members of the board, can be felt in terms of overall business risk, but also in terms of the specific operating expenses that my client must bear, expenses that are part of this new normal, such as government-mandated mitigation expenses, increased insurance costs, and claims expenses, liability claims. These are unprecedented, and they all bear upon the value of Southern California Edison for state assessment purposes. As a duly elected constitutional body in place since 1879, the State Board of Equalization is responsible for keeping public utility values consistent with current market realities to ensure that the utilities and ultimately their ratepayers are paying property taxes at fair market value. Members of the board, because you alone wield this power, not the staff, not the CPUC, or anyone else, and because this is squarely within your core constitutional function, we are asking you today to intervene in a matter of great importance to my client and the nearly 14 million ratepayers it serves throughout Central, Coastal, and Southern California. And I believe each of you represent Edison ratepayers. So what is our quarrel? What is our quarrel? Our quarrel with staff, members of the board, is that they simply don't account for the important realities presented by the wildfire crisis and the undeniable impact of these realities on Edison's property tax value. Now, staff will tell you that they already have accounted for the wildfire crisis and that they've made certain adjustments to Edison's value. But when they say that, keep in mind that staff has levied what we believe to be the largest value increase in the history of state assessment. This is even after the revised value that they submitted. So from Edison's perspective, it's bad enough to incur these massive expenses and to be facing this existential threat to its overall business. It's insult to injury when those expenses are not taken into account to reduce Edison's property tax value accordingly. So you may also hear from staff that this is all super technical or super complicated, or that we need to trust and defer to their appraisal judgment. But I say to you, this is a simple case. It's a simple case. The specific issues, and there are 4 of them, we will address below. To be sure, Edison's positions on these issues, which the independent EY report confirms, are 100% grounded in sound appraisal theory. But more fundamentally, members of the board, they're 100% grounded in common sense, given the wildfire crisis and the new normal. We'll get into this detail shortly with the assistance of the EY team. Staff will tell you, as they've told us, that they just did what they always do and treated Edison fairly. When they do that, please keep in mind 3 major red flags concerning staff's evaluation. If I could draw your attention to slide number 7. The first major red flag, members of the board, is that this assessment this year is a total outlier, a total outlier. The 2020 value hike against my client is well above the average increases it has sustained over the past 10 years, and it makes no sense in the context of the wildfire crisis. Staff will try and explain it away by saying that they've added $6 billion in new assets, but we know that asset additions and value increases do not alone determine value. In fact, there's no correlation at all if you look at it historically, which is what we see in slide 8. In slide 8, you'll see the orange bars representing the asset additions, and the blue bars, with the exception of the red bar, which is the current year assessment, represent the value increases. Now, you'll note that in 2015, with the retirement of the San Onofre plant, there was actually a net decrease in asset additions, but that didn't correlate to a decrease in property value. There was an increase there. And so you can see that the red bar is an outlier, and it becomes even more pronounced when you look at the past 3 years since the surge in wildfires in California beginning in 2017. You can see the asset additions and you can see the value increases. There's a true comparison for you. It's an outlier, members of the board. That's flag number 1. The second red flag is that staff keeps referring to these wildfire-related expenses as non-recurring or non-ordinary. That's one of the bases upon which they have denied these expenses. They're insisting, as we sit here today, that in this new normal, that the wildfire-related expenses are simply one-offs, and that isn't true. Now, if you can see in slide 10 that we have an increase in wildfires due to climate change, it's quite pronounced, and the expert we cited to earlier, John McWilliams, said that wild climate change is leading to more frequent and intense wildfires, storms, and flooding, and that they could become 900% more destructive in certain regions by mid-century, and that importantly, utility assets will also be increasingly exposed. So when staff says that these are non-ordinary or non-recurring expenses, keep that in mind. The third red flag, members of the board, has to do with the internal inconsistency of staff's approach. And for that, we turn to slide 11. And when I say internal inconsistency, we'll get into this a bit later with the EY team. But for now, understand that we have 2 main value indicators that we're relying on. Actually 2, there aren't any others. It's just 2. Historical cost and income, and they're both designed to measure the earning power of Edison. That's effectively what they are. It's called historical cost, but it's meant to address the earning value of a regulated company. And as the years have gone on, you've seen a wide disparity between these 2 value indicators. And your board's own guidance calls for that difference to be reconciled, and it wasn't reconciled here. In fact, the difference between the 2 is $9 billion. That's a disconnect that really calls this into question. So Edison filed a petition. This is the first board hearing they've had that any of us can recall, and they retained EY to help with this. And so what we're asking for the board is quite simple. We want to see Edison's value reflect the existential challenges it's facing with the ongoing wildfire crisis. And the solution we're proposing is actually simple and straightforward. We would like the board to enroll the value consistent with the EY report. Now, with this in mind, I would like to take the opportunity to address the specific issues that are before you that Ms. Garrett mentioned. So the first issue, beginning on slide 12, is the wildfire mitigation capital expenditures. These are expenses that Edison was required by the legislature to incur in order to mitigate the risk of wildfires. Slide 16 shows you an image, a visual of some of the things that they've been doing. But the important thing to note here is that these are expenditures that must be made. They're required by the legislature, and they must be made without a return on equity. And at this point, I am going to ask you to turn to slide 15, which talks about the concept of historical cost and rate base. And I would like to call upon my colleagues from Ernst & Young to walk us through what we're seeing here and how AB 1054 impacts the treatment of capital expenditures for property tax purposes.
Thanks, Marty. And this is Jason Chow with Ernst & Young. Good morning, members of the board. What I would like to do is expand upon HCLD and what you see on slide 15. So as we approach the appraisal and reading through the assessor's handbook and related guidance, we noted also the following statements. HCLD is one of the more important indicators of value for closely regulated public utilities. HCLD approach to value shall be considered if the income from the property is regulated by law. HCLD shall be considered if the regulatory agency uses historical cost less depreciation as the rate base. And also in further guidance, we see that the general practice of the California Public Utilities Commission and most other regulatory agencies is to use historical cost or original cost, less depreciation, with various adjustments as the rate base. So with all of this, it is our view that HCLD is the primary driver for rate base. And then further, and if you look on slide number 15, rate base drives the earnings of a utility, and the earnings of the utility will allow it to achieve its allowed rate of return. These are the economic parameters that Edison's business operates in. And thus, when considering a closely regulated utility, we have the following situation. If the capital expenditures can't earn the allowed required return, it cannot be included in the rate base. And if it's not included in the rate base, it should not be included in the HCLD indicator of value. So when we consider how to approach the HCLD valuation, and when we think about the capital expenditures being mandated by AB 1054, that clearly falls into this situation. So with that, Marty, I will turn it back to you.
Thank you, Mr. Chow. So the takeaway, members of the board, here is that rate base, HCLD is all about rate base. Rate base is about the public utilities earning on these assets, and the legislature has legally precluded Edison from earning on these assets. They need to be taken out of historical cost. It's just that simple. It's not more complicated than that. And the next issue that we wanted to talk to you about is insurance related. And it begins on slide 17. It is entitled Wildfire Insurance Fund Contributions. And these are expenditures that are made into the Wildfire Insurance Fund, and specifically Edison's initial contribution into that fund of $2.4 billion. These must be allowed, but staff has disallowed them. And their argument is that, as a general rule, that they are concerned only with future expenses. Our counter to that is, and this expenditure took place in September of 2019, just months before the January 2020 lien date. So they are viewing this as a past expense, and that, as a general rule, is true. But our counter to that is that the board's own published guidance, as we see on slide 18, the assessor's handbook, the board's own assessor's handbook, says that there are certain expenses that, if they're prepaid, you annualize. I'm going to have Ms. Wood tell us about that in just a moment, but the specific example it cites is directly on point. Prepaid insurance expenses. They call it a premium, but these are equivalent to that. The annual contribution is prepaid insurance, and it should be annualized. So I'm going to have Ms. Wood, Ms. Andrea Wood, the VP of Tax at Edison, join me on camera here. Ms. Wood, are you available?
Yes, I'm here. Good morning.
So to give you some context, members of the board, I'd like Ms. Wood to tell you what challenges the board that Edison is facing in procuring insurance for wildfire-related claims.
Yeah, so to kind of give you some background as to how the Wildfire Insurance Fund came into existence, taking you back to the 2017 Napa Valley fires, which created devastating losses. Around that time, it became very difficult for utilities in California to get wildfire insurance. This is primarily due, which I'm sure you know, is to the California's law of strict liability or inverse condemnation, which makes the utility liable for all damages of any fire in which their equipment is involved, regardless of fault. So that means that if a bad driver runs into one of our poles and it starts a fire, burns down a strip mall, we're held liable, even if the poles and wires were maintained and in good shape. So within SCE's territory, back in 2017 and 2018, we experienced at that time 2 of the California's largest fires, the Thomas Fire, and followed by the Montecito mudslides, and the Woolsey Fire. By then, insurance costs were just prohibitive, and many carriers even refused to write policies. For example, in 2018, our cost of $1 billion in insurance coverage was over $300 million. And we've stated that in our 10K filings in our financial statements. So if you equate that to a homeowner's insurance policy, that means your annual insurance premium for $1 million home would be $300,000 a year. So it's just the costs are just through the roof. And then to make matters worse, PG&E filed for bankruptcy, which eventually led to the passage of AB 1054 that established the Wildfire Insurance Fund. In this context, the utilities would pay upfront an amount and an amount over time to pool their funds together to cover claims for future fires. And, SC, as Marty said, SC's upfront premium was $2.4 billion with a roughly $100 million a year for the next 10 years. So after an internal cost benefit analysis, we decided that it made sense to opt into the insurance fund. Because it provided us coverage that we might not be able to even be able to procure in the open market. So that's sort of puts some things in context for you. I'm going to turn it back to you, Marty.
Thank you, Ms. Wood. So members of the board, I don't think there's any dispute that these are insurance expenses, insurance premiums, and to kind of remove the issue from doubt, I would direct you to slide 19. And I'm going to call on Mr. Manos here in a second, who's also on camera, but just take a look at slide 19, if you could for a second. So this is the legislature's own uncodified bill language to AB 1054. They refer to this as a wildfire insurance fund, okay? And they indicate their intent to provide a mechanism for the public utilities that's more cost effective than traditional insurance. This is insurance. There is no question about it. Staff says it's not insurance. I don't understand how they can make that argument. And with that, I'm going to turn it over to Mr. Manos from Ernst & Young and ask, in your view, from a valuation and appraisal perspective, should this expense be treated as prepaid insurance?
Thank you, Marty. Good morning, members of the board. So while SAPD includes the $95 million annual payments over 10 years, they do not consider the $2.4 billion initial outlay to participate in the AB 1054 Wildfire Insurance Fund. Their reasoning is it's considered a single one-time required payment. However, in this view, this is considered a prepayment to participate in this insurance fund. And a prepayment is an amount paid in advance of goods or services being received. So prepayments would relate to required, upfront payments in full or in part before goods or services are provided. And this is exactly what the initial $2.4 billion payment represents. The initial portion of the full contribution required for coverage of, $1 billion or more in damages or claims for wildfires based on AB 1054. So based on the assessor's handbook, as Marty had mentioned, prepayments, insurance prepayments should be annualized when applying a direct capitalization method such as the CEA. Otherwise, the results of the analysis would be distorted by what is considered normal levels of operating expenses given that the CEA is capturing the property value based on a single period in time. So based on the assessor's handbook, the treatment of the prepaid expenses is that they are annualized, even though some expenditures may not actually occur on an annual basis. So in this case, SCE is prepaid the $2.4 billion, but would still need to account for that expense going forward if you were doing a capitalized earnings approach. So by excluding the initial payment, the CEA is resulting in an artificially higher value. So in lieu of participation, as Ms. Wood had mentioned, SCE did an analysis, and they would obviously be required to spend well above the approximately $340 odd million that we've included in the SCA calculation, if they were even able to get private insurance to cover anything beyond $1 billion. So in our estimation, I mean, this is exactly prepaid insurance and should be annualized over the term of the AB 1054 Wildfire Fund.
Thank you, Mr. Manos. Members of the board, the third issue that we have concerns liability claims relating to the wildfires and mudslides that Ms. Wood referenced that took place in 2017 and 2018. So staff has disallowed these expenses as past and non-recurring, but this is just wrong. Staff says that this is a past event because of an accrual that Edison took for financial accounting purposes, and because that accrual took place before January of 2020, that makes it a past expense, but that's wrong. And I'd like to call upon Ms. Wood to join us again to explain the accrual to us and to talk about what these claims relate to.
Yes. Okay. So going back to the Thomas and the Woolsey fires in 2017 and 2018 that I mentioned earlier, SCE had estimated their potential claims to be about $4.5 billion and made that accrual in their financial statements. These are amounts that are to be paid over time as the investigations are completed and fault is determined and then settlements are reached. The payment of these claims started in 2019 with about $300 million paid to local public entities. And that was followed by a $1.6 billion payments in 2020 this year. And in fact, the estimate of the cost of the liabilities was further increased in 2020 by an additional $1.4 billion for a total of almost $6 billion in estimated liabilities. Payments in 2021 and beyond are expected to reach $4 billion. So, you know, clearly this is an ongoing expense, cash payments that will be going out over time. Back to you, Marty.
Thank you. Thank you. So, members of the board, if I may, I'd like to address the fourth issue that has to do with weighting. And this is where, you know, we mentioned this earlier in the discussion when I mentioned slide 11. And slide 26, if you could turn to, contains the key passage here. So this is the difference between the value indicators. Remember, HCLD and income, the value indicators are supposed to roughly approximate the same value. They don't always line up exactly. I mean, in fact, they never do. But significant differences are called out in the assessor's handbook. This is, again, your board's own guidance that says that if you've got an HCLD indicator, a historical cost indicator that's much higher, and in this case it's $9 billion higher than the CEA indicator, the income indicator, then that indicates that something's wrong, that there's obsolescence. And so we have asked for the board to consider this in the weighting, and the staff has maintained the 75-25 weighting. Historically, even as the value indicators have grown further and further apart. So as you can see on slide 27, this is an overlay, right? This is the slide that we saw earlier with the flat line of just no additional weighting being given to CEA. And slide 28 also shows that despite the wildfire crisis, which is another variable that has changed significantly, that the CEA weighting has stayed flat. And if we have a few minutes before we wrap up, I would like to I would like to ask Mr. Manos to or Mr. Chow from Ernst & Young to step in here and to tell us from an appraisal standpoint, how did you address this issue? What is meant by obsolescence, and how does it apply? How does obsolescence apply in this case?
Sure. And thanks, Marty. This is Jason Chow again with EY. So, as part of the appraisal process, and certainly when you look at the deviations then that Marty had illustrated, the concept of obsolescence, and certainly, in this new normal, which is being caused by the wildfires, this impact of the wildfires then certainly has a negative impact on Edison's business. And this negative impact is really a form of obsolescence. And with this, it should be reflected in the value indicators. Measuring this obsolescence will need to be quantified and then reflected as adjustments in each of these indicators, both the CEA as well as the HCLD. And how you measure this adjustment is going to be based on data available, and the use of this data then in quantifying this obsolescence adjustment. Furthermore, as we perform the valuation analysis, really it is better, the better the data, the more reliable and the more supportable that adjustment is. And certainly that is a key consideration then as we applied, both of these indicators of value, the CEA and the HCLD. So with that, Marty, I'll turn it back to you.
Thank you. The takeaway, members of the board, is that it is appropriate based on the circumstances of this case to give more weight to income than to historical cost. That's an appropriate recognition of the new normal, which brings us to our conclusion. And thank you for your patience in hearing our case today. But in closing, members of the board, the wildfire crisis is real and it's here to stay. This new normal has been incredibly disruptive and confusing because it means that the world as we used to know it will no longer exist for the foreseeable future. And it's understandable for human beings to resist change as long as possible to avoid the challenge of trying to figure out how to deal with a world that's different from the one that we've known and the one that we prefer. And one way that we resist change is we fall back on what's familiar and routine in hopes that we can just sort of ride out what we hope is a rough patch. But this is not a rough patch. I mean, this is it, right? This is our new reality. And in a sense, it appears that that's what staff has done with the 2020 valuation. Instead of embracing the new normal and exercising proper appraiser judgment in new ways in response to this new state of affairs, staff has relied on routine approaches, which result in the outlier value we have this year and trying to put square pegs into round holes. So referring to wildfire expenses as non-recurring when there's near unanimity in the scientific community to the contrary is, well, it's problematic, to say the least. So members of the board, when proper appraiser's judgment has not been exercised, as is the case here, deference to that judgment is not appropriate. The members of the board, we request that you perform your constitutional duty to intervene, to adjust SCE's 2020 valuation so that true fair market value under this new normal is established. Only then will SCE and its ratepayers not be further harmed by the new normal of the wildfires and the mudslides and so forth that will only increase in severity. It's been an incredibly challenging time for the company, as you can imagine, and the property value has to reflect that. So for this reason, and all the reasons we've discussed, we respectfully request that you enroll the value consistent with the EY report. Thank you, members of the board.
Thank you. Now we'll go to presentation by Mr. Moon. Is Mr. Moon available from our State Assessed Properties Division?
Yes, I'm available. Richard Moon from the legal department, and with me are Jack McCool and Dan Jenkinson for this with the State Assessed Properties Division. In this matter, petitioner is requesting a unitary value of $22.9 billion, which is a $6.9 billion reduction from the board adopted value. Petitioner states that it's requesting this large reduction because of increased risks due to catastrophic wildfires, particularly in 2017 and 18. But their $22.9 billion requested value is less than even their 2016 value, which was before the 2017 wildfires. As well, they're requesting the $6.9 billion reduction, even though this past year they've added about $5 billion in assets. And since 2016, they've added about $15 billion in assets. And we want to be very clear that SAPD is not arguing that wildfires are irrelevant or that they're not catastrophic or that they appear to be growing in frequency or that they will not recur or that they do not represent risk. What staff is saying is that after considering all of the effects of the increased wildfire risks, all appropriate adjustments have been recommended or made to account for those risks. In 2019, those adjustments totaled about $2.1 billion. And in 2020, this year, those adjustments totaled about $1.9 billion. Staff's treatment of wildfire risks is consistent with that of the California Public Utilities Commission, which is the regulatory agency responsible for determining how these risks will affect petitioners' business, including in light of AB 1054's passage. And as you know, AB 1054 was enacted in 2019 specifically to help mitigate utilities' risks from wildfires and to ensure their continued viability. As part of its responsibilities, the PUC decides the rate of return a petitioner is allowed to earn, and this rate of return takes into account all factors that might affect their business, including risks related to wildfires. Prior to the passage of AB 1054, Edison petitioned PUC to raise its equity rate of return by 6% to account for increased risks to its business associated with wildfires. But after the passage of AB 1054, the commission ordered petitioner to review its request. Petitioner did such a review and concluded that its risk had been mostly mitigated and lowered its request from 6% to 0.85%. But the PUC rejected even this smaller request, and they concluded as follows. We find that the passage of AB 1054 and other investor-supportive policies in California have mitigated wildfire exposure faced by California's utilities. Notably, the reasons petitioner asked for a smaller 0.85% increase at the PUC are the same general reasons it's asking for a reduction in value here. Specifically, the magnitude and recurrence of the wildfires to counter the effects of inverse condemnation, or what they refer to as a strict liability standard, and increased regulatory risk from lowered credit ratings. With regard to inverse condemnation, the PUC effectively found that even though AB 1054 did not change the liability standard, it provided a mechanism for petitioner to be reimbursed for what they pay out. Not only that, but PUC held that the new prudency standard created by AB 1054, and this is their words, does not introduce a new risk, but is rather a solution that is expected to limit utilities' financial exposure to wildfire liabilities in the future. With respect to increased credit risk, SCE itself in its 2019 annual report acknowledges that credit rating agencies upgraded its credit outlook from negative to stable. CPUC, for its part, emphasized that SCE has an investment-grade bond rating, and that after AB 1054 passed, they concluded these investment-grade ratings are a good indication that California regulatory risks are low. Even though PUC rejected Edison's request for a 0.85% increase, SAPD allowed that increase, and it resulted in about a $1.3 billion value reduction for this year. And it's important to remember that Edison asked PUC for that increase to cover additional risks they felt AB 1054 does not mitigate. But now they're effectively telling your board that 0.85% is actually not enough, and they need billions more deducted. But again, the general reasons being given here were also given to the PUC, and the commission, who again are the experts in this area, rejected each and every reason. In doing its assessment, SAPD took all relevant information into account and appropriately computed both an HCLD and an income indicator of value. Because the HCLD indicator of value begins with the actual assets PUC allows petitioner to earn a return on, staff considers it the most reliable indicator and weighed it more heavily than the income indicator. Petitioner citations do not apply here and actually fully support staff's position. Specifically, Rule 8 says the income method is preferred when the cost approach is unreliable. HCLD is not unreliable. It is actually the most reliable. Petitioner also assumes that any difference between HCLD and CEA is because the HCLD is too high. But there's nothing that makes that necessarily true. It's entirely possible that the CEA is far too low. With respect to their specific issues, first, the $4.5 billion accrual for the 1718 wildfire lawsuit liabilities. Petitioner misunderstands what we're arguing. The $4.5 billion accrual is an estimate of expected lawsuit settlements that arise from those wildfires that occurred in 17 and 18. And while this lawsuit liability may affect the value of the company, in other words, the business as a whole, it does not affect the value of the taxable property. Petitioner claims that this is not really a liability, and so it should be allowed as an expense. Notwithstanding the fact that the appraisal report done by Ernst & Young says that this represents an actual outstanding liability, the EY report also states this amount is not a liability. This is the accrual of a future expense required as part of the ongoing operations of SCE. And we agree with this. This is exactly right and exactly why a liability is not allowed as a deduction for property tax valuation. A liability like this one is accrued on its books and not paid in cash at the time of accrual. And while it might be part of the ongoing operation of the company, it is not part of amounts paid to operate the taxable property. And in this regard, the EY report admits even more clearly that this liability affects the value of the entire business, not the taxable assets. It states, it is reasonable to assume that a prospective buyer would consider this expense as part of the going concern of the business operations. Therefore, this liability can be thought of as affecting what a potential buyer might pay if they were buying the entire company, but it does not affect what a buyer would pay for only the taxable assets. And Rule 8C, cited by the petitioner, fully supports staff. It says the net return which a reasonably well-informed owner and reasonably well-informed buyers may anticipate on the valuation date that the taxable property existing on that date will yield under prudent management. Just as importantly, however, SCE has indicated that they've applied to PUC to recover these amounts through a rate increase. Now, PUC may deny that request if it finds petitioner acted imprudently, but either way, a deduction is not appropriate. If PUC allows the rate increase, petitioner will recover these amounts, and thus the deduction is not appropriate. And if PUC does not allow rate increases because of a failure to meet the prudency standard, petitioner's property tax value should not be reduced because property must be presumed to be operated prudently, as was just cited in Rule 8. If the assets aren't worth as much because they're operated imprudently, that may be the fault of management, but it's not the fault of the assets. And in this regard, the PUC has stated in Edison's rate increase request, undisputed in this proceeding is the notion that the investor-owned utilities should not be awarded with an increased return based on risk that is associated with imprudent management. Similarly, it should be undisputed here. In undisputed, there should be no reward in the way of a decreased property tax valuation for imprudent management of assets. Thus, either way, it's inappropriate to allow this amount as an expense. With regard to the $400 million wildfire mitigation capital expenditure required by AB 1054, as stated previously, PUC determines a rate of return to apply to petitioner's assets. This rate, the capitalization rate, consists of two parts, an equity rate and a borrowing rate. AB 1054 only prohibits petitioner from earning its equity rate of return on these assets, and this is acknowledged by petitioner. Therefore, SAPD appropriately removed the equity portion of the cap rate and left in only the borrowing portion. Petitioner made much during the appeals conference of how these assets are financed, but how these assets are financed is not relevant to its value. What's important is that petitioner owns the assets and is able to recover its investment. Again, petitioner states itself in the EY report that proceeds from the financing entity will be transferred to SCE, at which point SCE will consider their initial $400 million investment repaid. It also states that ratepayers will be paying a fixed charge for recovery of this amount. Finally, for the AB 1054 required initial contribution to the wildfire fund, this is not a deductible expense. Petitioner requests reduction for the $2.4 billion initial contribution, but it's not deductible because it's a one-time cost paid in the past, specifically in 2019, that will not recur in the future. In other words, it will never need to be paid again. Petitioner, again, itself acknowledges this, identifying it as a non-core item in its annual report. And it defines non-core item as including income or loss from discontinued operations and income or loss from significant discrete items that management does not consider representative of ongoing earnings, such as income and expense related to changes in law. That's exactly what this payment is. Petitioner, however, calculates and amortizes a future expense for accounting purposes over 10 years, but that is a pure estimation. When they do that, what they're actually acknowledging is that that future accounting expense is not a cash flow, and they don't really know how long the fund is actually going to last. And it's telling that they state in their annual report, changes in the estimated period of coverage could lead to material changes in future expense recognition. Again, it's important to remember that this amount is not actually paid in future years. It's only an expense to compute accounting income. It is not an expense to compute capitalized income for property tax purposes because it's not part of cash flow. And this is a fundamental tenet of appraisal practice. Petitioner points to our Assessor's Handbook 502 as supposedly supporting its position that accounting expense can be deducted. However, when that language is read properly and in conjunction with Rule 8, that language fully supports staff's position. What AH 502 is referring to is recurring prepaid amounts that represent future cash flows. The example given in the Assessor's Handbook is of insurance that is prepaid for 3 years. The handbook allows annualization because there's an assumption that after the initial 3 years, there will be another outlay of cash that covers the next 3 years. It is therefore estimating an annualized payment only because it will recur every 3 years as a cash flow. That is not what is happening here. Although we do not believe this payment is best characterized as insurance, whether it is or isn't is a red herring, and it's meant to distract from the main point, which is that this payment is a past non-cash expense that will not recur. Petitioner has made much of the fact that these wildfires will continue to occur, but any predictions that additional contributions to this fund as required by AB 1054 must be made are pure speculation. The only thing that's known is that contributions will need to be made for an additional 8 years, and we've allowed those contributions. And again, petitioner itself acknowledges this. Petitioner admits that the time period the fund lasts is highly dependent on assumptions. And as an example, in its annual report, it gives a scenario where the fund might last for 20 years. Before the PUC, petitioner argued the fund could run out by 2035, which is about 15 years. But the PUC said arguments positing that the fund may be exhausted before 2035 are premature. Also, the entire purpose of AB 1054 was to reduce wildfire risk to utilities like petitioner, in part by requiring mitigation plans, safety certifications, and capital expenditures. Assuming it's successful, presumably it will lengthen the life of the fund. It may be that more, perhaps even huge sums of money will have to be paid into this fund or into a similar fund. But it's also possible that no money or something far less than 2.4 billion will need to be contributed. But that's the entire point. Nobody knows. And so in conclusion, SAPD acknowledges the serious consequences and the risks of wildfires, but SAPD has recommended or made all appropriate adjustments. Petitioner, on the other hand, is requesting a $6.9 billion reduction in value even though making such reductions would violate generally accepted appraisal practices, even though a $6.9 billion reduction takes them below their unitary value in years prior to the 1718 wildfires, even though they added $5 billion of assets in 2019 and $15 billion in assets since 2016, even though it admits AB 1054 has brought a material improvement in risk, even though PUC has stated petitioner has no additional risk for wildfire that has not been accounted for, and even though SAPD has made an additional reduction to petitioner's unitary value for wildfire risk that CPUC denied, and the petitioner requested of CPUC to account for additional risk not mitigated by AB 1054. And for all of these reasons, we recommend a reduction in value as reflected in the hearing summary and denial of the petition in all other respects. And we would be happy to take any questions. Thank you.
Thank you, Mr. Moon. I see Marty Zakushian still on the line here. You have 10 minutes for your rebuttal.
Thank you, Mr. Chairman, and I am going to turn it over to some of my colleagues from the EY team, but some introductory remarks. First of all, I seriously, I take issue with the characterization of the largest tax increase in the history of the State Board of Equalization as we're requesting some kind of a reduction. That to me is just like the old sales markup trick. We're gonna mark this up as the highest tax increase in history, and when we request for it to be brought back down to normal, reasonable levels, we're asking for a tax decrease. I question that. I take issue with that. So there is a lot of material here to go through, and in the limited time we have, I'll try and pick up on some of the highlights. First of all, we're not inconsistent with CPUC. The CPUC has prevented us, or the legislature has precluded us from earning on the capital expenditures to the tune of $400 million. And that is the heart and soul of rate base, and we want it removed from rate base, consistent with the CPUC. Now, this concept of the risk premium, and Mr. Moon spent a lot of time talking about that, but as Ms. Garrett mentioned in the introduction, we're not contesting the risk premium issue. So let's just take that off the table completely. That has nothing to do with this appeal anymore. We're asking for specific wildfire-related adjustments, and Mr. Moon went back and forth. He said, we're not saying it's not recurring. Non-recurring. And then he said that they're non-recurring. And in his brief, he says on page 9 of their brief, lines 11 through 13, that the cost for which petitioner seeks a reduction are both past expenses, which are not anticipated to be incurred again in the future. That says it all. That says it all. They say one thing to the board today, they write something else totally different. So they believe it's not recurring. You've heard that a few different times during his presentation. And we have specific wildfire-related adjustments we are seeking, and they do affect the business as a going concern. And that's what unitary valuation is all about. It's not picking off an asset here and picking off an asset there and looking at the value in a vacuum. The unitary concept is the value of the business as a going concern. In terms of the earning issue, there is no earning on debt. We can get into that in a moment. And this is clearly prepaid insurance. I mean, you heard what he said. This is a form of insurance. And so in the middle of this wildfire crisis, what Governor Brown calls the new normal, at the end of the wildfire fund, if it goes to the end, we're not going to have to replace that with other insurance. In the middle of this wildfire crisis, the only reason that the wildfire insurance fund exists is because private companies won't write insurance. So the insurance is going to be an ongoing cost. I don't understand how he can say that. Now, I would like to call upon Ms. Wood. Are you there?
Yes, I'm here.
Ms. Wood, would you take a moment to address the comments Mr. Moon made regarding the 2018 claims?
Yeah, I would just say that, you know, those particular claims are not covered by AB 1054. AB 1054 only applies to, you know, claims and fires that occur after its existence in 2019. So, you know, those claims are going to have to continue to be paid. I understand if they want to ignore the accrual, but it's hard to say you're going to ignore the cash flow of the payments over the next few years. And as far as the comments about a willing buyer being able to buy the assets without assuming the claim liability, that's not possible. The CPC would never allow that to happen because then there's no collateral for the claims themselves. So I don't know, Marty, was that sufficient?
Yes, thank you. Thank you. That's very helpful. And then in terms of the I'm going to turn it over to the EY team in just a moment, but in terms of the disparity between value indicators, staff seems to poo-poo that. Staff seems to say, well, of course we can have variances, and we heard this repeated in the hearing summary. $9 billion difference, whether CEA is too low or HCLD is too high, needs to be reconciled. That's $9 billion. I mean, let's put it in perspective. The budget for the city of San Francisco is $12 billion. Okay, there are many publicly traded companies that have market caps below that amount. Many household name public companies that have that. $9 billion is a lot of money, and they've utterly failed to reconcile the two. They've just applied the same 75-25 weighting without reconciling, without looking at it and saying there's obsolescence here. Like our assessor's handbook tells us that if we have a value difference this is profound, that we need to reconcile and we need to look to obsolescence. So if the EY team is available, I'd like to call on somebody to address the issue of the claims liability and the prepaid insurance.
And that would be Greg Manos. Greg, are you able to?
Yeah, I'm on. So, as I mentioned before, clearly, the $2.4 billion is considered a prepaid insurance. In light of the fact that there is AB 1054, if there wasn't AB 1054, there would be, as Ms. Wood said, public insurance or private insurance that would be required, which would be cost prohibitive, obviously, on an annual basis. So what in our view, what AB 1054 does is provide that insurance, for SCE and the other utilities in the state, in lieu of going out and getting, public or private insurance on their own. Now, if let's just say, for instance, the fund does exhaust in 5 or 10 years, or it could be even sooner, I guess, if the wildfires are ongoing and as large as they've been, the utility would be required to go out and get insurance to replace that. So, by disallowing that expense, they're artificially, increasing the value of the HCA the CEA, when in fact that is an ongoing expense and would need to be paid, but for AB 1054. So in our view, if petitioner didn't participate in AB 1054, they would be required, or they would have to go out and get insurance on their own, and it would be far in excess of the $340 million adjustment per year that we're claiming. So just because they made this payment in the past, doesn't preclude it from being considered prepaid insurance, because that's exactly what it is, and it's required to participate in this public insurance fund, if you will.
Thank you, Mr. Manos. So I would also draw your attention, members of the board, to slide 20, and staff utterly ignores this. Edison treated this as prepaid insurance on its financial statements and its public filings. That's something that the board should consider. The bottom,
Marty, one other quick question, or one other quick mention is that they've included the $95 million per year, which is the amount that they're paying, in addition to the 2.4, but that doesn't cover the full normalized expense level that would be required going forward. If AB 1054 didn't exist, so you kind of have to take the two together in order to be able to assess how much the insurance would be on a go-forward basis. And by just disallowing it, again, just by disallowing it completely, you've overvalued the CEA method.
Thank you, Mr. Manos. Would somebody from the EY team address the claims liability portion? Because it seems like staff wants to have it both ways, right? So they want to talk about cash for purposes of the prepaid insurance. Oh, this is a past expense. But then when we have a claims accrual, liability accrual, an accrual of an expense in a previous year that's supposed to forecast a future expense, right? Now they want to have their cake and eat it too. Can you walk us through that, please?
And so we're not contesting that this was a past event. I mean, it clearly was, and it clearly was prior to AB 1054. So it would not be, obviously would not be covered in AB 1054. But just because it's a past offense, a past event, and an accrual on the statements of SCE does not mean that that it's not ongoing, because clearly it is. And I think the petitioner even had mentioned that even in 19 and 20 they're still accruing for and will have expenses out in the future for wildfire liabilities that aren't covered under AB 1054. And as Marty had said, this has not been paid yet, so it's clearly an expense that's going to happen in the future. And in this case, we know it's going to happen in 2021. The amount is known at this point in time, hence why Edison has put it on their books as such. And really, we're not arguing that it's all $4 billion, because some of that $4 billion is covered under insurance. We're really arguing the amount that is not covered under insurance that will need to be paid out of operating cash flow of SCE over the next year.
Right, and the whole point of having to accrue this liability and disclose it in a public filing is to let the world know that there's a high level of certainty that these expenses are going to recur. And so, I think that that's a very significant point. Mr. Manos, anything on that?
Well, and the fact that we know they're going to occur, and the fact that any potential purchaser of these assets would take that into consideration when they're looking at the value of this business as a whole, or unitary value, as Marty had mentioned. I mean, it clearly is a factor, because they know out of the operating income of these assets, they're going to have to pay about $2 billion of claims next year.
So let's just underscore this point. So in the real world, right, a prospective purchaser in the real world, right, a prospective purchaser is going to have to account for these future liability expenses in considering whether to buy these assets, right, and at what purchase price.
That's 100% correct.
So for staff to say that that this isn't going to recur, or a prospective buyer wouldn't have to factor this in, makes no sense. Same with the insurance piece. It's all part of the same theme. And members of the board, staff says it's not recurring. You don't think if the wildfire fund, let's just say for purposes of discussion, is never replenished, which it will have to be, but let's just say it's wound up, it's never replenished. You don't think that Edison's going to have to go and find insurance somewhere else? Right? I mean, is this sort of what it's come to? I mean, if staff agrees that the wildfires are the new normal, then they need to accept this level of expenditure as the new normal, and they're not doing it. They say they are, but they're not.
Okay, thank you. Members, we went over quite a bit here. I just want to check in with staff and the members in terms of our lunch break here. I'm wondering if we can get away with, instead of doing a full hour, I'm wondering if, I don't know, is a half hour, 45 minutes plenty or sufficient?
We're used to, Vice Chair Schaefer, we're used to 20 or 30 minutes.
You want a half hour?
That's
yes.
fine.
Is staff okay with that?
Yes, sir.
We are prepared to take a break, and we're also prepared for any questions and move forward, whatever the board's pleasure.
Okay, why don't we go ahead and take at least a half hour break right now? So it's almost 12:30. When we say we'll reconvene at 1 o'clock and then get into our questions and then the decision, is that good? I'm seeing nods, and
I'm okay with that. Have we heard from Ms. Cohen?
Well, she's actually abstaining from this whole discussion, so she should be okay. I think originally we were looking to take the break to accommodate her, but actually she's on break right now until we finish this item. So I think we're okay. I think it's pretty much on us then.
Is Ms. Yee still with us? Controller Yee?
I believe she is.
I have a hard stop at 1:45, so I'm fine with a half hour break.
Okay, well, why don't we do a half hour then? All right, so we'll reconvene at 1 o'clock. Thank you all, and we'll see you at 1 o'clock.